Hi, this is Cora Stack here, Dr. Cora Stack. I just wanted to wish all my friends and supporters and readers on my networks and on my YouTube channel and LinkedIn and other channels a happy, calm, and peaceful weekend. Now, I have been talking there about my Supreme Court application for leave to appeal, and it has taken me a long time to try and condense the key points that I'm interested in being addressed by the Supreme Court. I mean, these things take a long time to for your mind to process in a way that you can kind of explain it yourself. So some of the videos have been like giving lectures and then saying, no, that wasn't good enough. I have to do it better and the next time and the next time. So it's a process of reduction, which I've used over many years in mathematics to try and simplify very complex ideas and think about them, how you can represent the ideas better, how you can refine them, reduce them, and simplify them. And that's a process which is very invisible to most people, but can lead to very deep clarity after a period of months or years even. And it's often kind of minimized or discarded, dismissed by people who are not experts in the field, or perhaps would like to dismiss your contribution or minimize it, which has happened to me for most of my career. So, I feel that the work I've done here on constitutional law has followed the same process as perhaps what I did in my PhD, where I felt, how did I do all this work and end up with nothing? And it turned out to be a significant contribution to the theory of nilpotent algebras, and it was a major advance, but because nobody really understood it in Ireland or elsewhere, people did understand it, but because it wasn't understood here in Ireland, it was, in my opinion, my contribution was completely minimised and dismissed or whatever. And this can happen, it's just not me, this can happen to anybody who works in a very difficult area, perhaps who then enters the job where research opportunities in that area are not available, and so the work becomes hidden and not sufficiently recognised. So I have used the same process of reduction over many months in my constitutional law work, and indeed in other work, where it seems to me that what is striking a chord with people around the world in terms of looking at the analytics on academia.eu and other platforms is abuse and abuse of power, and how abuse of power everywhere is so hidden, covert, and how it manifests itself in behaviours. And it's in higher education, it's in politics, perhaps perhaps you could say, perhaps it's in law, perhaps it's in the courts, perhaps it's in communities, in families in particular. There's a huge interest in my work in family law, and in power dynamics everywhere. So I have I would say the work I've done on power dynamics everywhere, there is a repeated pattern. It seems to be, if I was to put one word, it's about control, power, narcissism would be a good word. It's people might say it's more like the dark territory, that it's everywhere. It's now even embedded in legislation, and it's almost becoming the new normal, this kind of way of behaving, dynamics of power and control and deflection, all these techniques of reframing, all of that seems to me to be all about manipulation and gaslighting and winning using these underhand tactics and getting your way or whatever you want using all of these tactics. So it's a pattern of behaviours which I'm seeing right across the board, and I'm writing about in so many different areas, and it seems to be striking a chord with so many people around the world reading about my papers. And one common theme is abuse and the abuse of power and power dynamics, and that affects a huge amount of people. A huge amount of people feel undervalued at work, they feel minimised, they perhaps feel minimised or dismissed in marriage, they feel that perhaps in the workplace or in communities and societies, everywhere in politics, people feel excluded. And so there's a kind of this closed system that I'm talking about in my constitutional law is just a mirror of what's going on everywhere else. And I suppose it's no surprise to find it or to see it in law when it's, part of what's going on everywhere in the world, and a way of systems protecting themselves or institutions protecting themselves, whether it be families or institutions of all kinds that we now live in. And I'm advocating for more democracy in institutions, that we should have more democracy in institutions. And I'm even saying, how this might present itself in my Supreme Court challenge, how we might look at concepts like constitutional blind spots, and look at the concepts of constitutional maintenance, constitutional coherence, and constitutional continuity to bring more accountability into challenges, particularly with regard to time-sensitive issues or matters such as elections. And so, but the power dynamics that I have been talking about appear everywhere, and people have two choices. They have a choice to use their power in a constructive way to make things better for the world, or the other choice is to abuse their power and to protect themselves or their institutions or their allies or their friends. They have the choice to do both. So, but there has to be oversight, I think, and I'm just suggesting in my Supreme Court case that the Supreme Court look at oversight systems or methods, or try and first of all identify that there has been a serious problem here in the 2025 nomination and election processes, and then what that leads to the concept of a constitutional blind spot, and then what to do about it, and that leads to the issue of constitutional maintenance, and then constitutional coherence and constitutional continuity. So it leads to a kind of a theory of constitutional law, which I don't think has been there before, but it's for the Supreme Court to examine, or for constitutional theorists to look at in general. So it's in a lot of my papers, but I'm trying to, from the point of view of the Supreme Court case, I'm trying to narrow it down to eight very straightforward questions, so that it's not something that could, when I went in initially, I think a court could be overwhelmed with the questions. So I've kind of narrowed it down, and I've shared it with the public, because I think it's important that there is, that these things aren't hidden behind closed doors, that it's very clear what the questions are, and then everybody can say, well, they're reasonable questions, they're not unreasonable, they're balanced, they're fair, they're proportionate, and they are worthy of consideration. And perhaps constitutional theories later on, constitutional theorists will maybe extend some of that work into their own constitutional law research, and that would be something that I'd really be delighted if this work created a new area of constitutional law. And I think there is the potential for it to be very significant in terms of a bridge to a new area of constitutional law. And I said that about my first paper in the Pacific Journal of Mathematics, that I felt my first theorem would end up in significant developments, or could, in the theory of nilpotent algebras, not knowing in a million years that that's exactly what it did. So hopefully these papers in constitutional law will provide a new direction for constitutional law, particularly in time-sensitive elections and related matters.